The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 3 cases that will be submitted this morning. Those cases are Toby Thornton versus American Interstate Insurance Company. Second case is the State of Iowa versus Bradley Graham. And the final case is State of Iowa versus James Harris. All 3 cases will receive oral argument. Before announcing the arguments in the first case, let me welcome the students from Southeast Polk High School. I'm glad you're here this morning. We'll now hear the arguments in the Thornton case. Mr. McCormick.
May it please the court, as you know, we are representing American Interstate in this appeal from a $284,000 compensatory damages award and $25 million in punitive damages. Toby Thornton was severely injured when his semi-truck overturned in June of 2009. He received very severe injuries that required hospitalization and treatment and surgeries at university hospitals in Iowa City, subsequently rehabilitation activities at a hospital in Cedar Rapids. American Interstate got immediately involved in the workers' compensation coverage issues dealing with the injury, and a claims adjuster started working on the case the day after the accident. And the record shows that American Interstate paid full benefits under a workers' compensation statute from then until now, when it is continuing to pay benefits as a result of the proceedings in the workers' compensation case. But in 2013, Thornton filed a bad faith case against the insurance company, alleging bad faith in the handling of the workers' compensation claim. And that's why we're here today, because this is what resulted in the compensatory and punitive damages awards that we are appealing. As you know, because we raise a constitutional issue about the punitive damages, the review on that issue is de novo. The Supreme Court in State Farm against Campbell, which we believe is probably the most significant case for this court to consider in assessing the punitive damages award, held that there are limits to punitive damages that are imposed by the federal constitutional due process clause. The court said in that case, echoing what had earlier been said in the BMW case, that there are 3 guideposts for a court to look at in reviewing a punitive damages award. One is the alleged reprehensibility of the misconduct that resulted in the bad faith award. Then the disparity between the award and the harm to the plaintiff, usually measured by a comparison of the punitive damages to the compensatory damages in a case where substantial compensatory damages have been awarded. And the third is the comparable civil or criminal penalties in cases other than
Mr. McCormick,
faith case.
what do you think is the maximum punitive damages under the United States due process analysis that a jury could award in this case?
We think it had to be in the single digits. That is, not more than a multiple in a single digit of the $284,000 compensatory damages award.
So that'd be 9 at least. Is that what you're
Could
saying?
be, although the court said that the outer limit in most cases of the comparison or the disparity is 4 to 1. And I tell you, the case I liked best, of course it helps us, but I think it is a representative case that's very close to home. It's the decision written by Judge Pratt in the Bullmeyer case that we've got cited in our brief and discussed there, where there had been a $275,000 punitive damages award. The judge found that the district court had appropriately permitted a compensatory damages award of $10,000, so he upheld that. But he applied the Campbell factors in that case and analyzed, I think very carefully, the 3 guideposts as they applied to those facts and decided that a 4 to 1 ratio, reducing a 28 to 1 ratio to a 4 to 1 ratio was an appropriate disposition of the constitutional issue.
As
And
an-
counsel, I'm sorry, in that case, he applied, one of the guideposts he looked at, which is, I think, very significant here, is the legislature's penalty provision in Iowa Code Section 86.13, and that's only a 50% in addition to what was withheld. How would that work here when benefits had been paid all along?
We think that under the reprehensibility factor, there is little of, if any, evidence of reprehensibility. We do not complain in this appeal about the judge's pretrial determination that it was unreasonable for American Interstate to take to hearing the issue of permanent disability. But that really doesn't affect much, except that it required about an hour hearing in which evidence was presented concerning the extent of the damage and the effect on Mr. Thornton's ability ever to have gainful employment. And the only dispute in that hearing was about whether or not he had a residual ability under some circumstance to find a job and have gainful employment. But apart from that, we don't think there is support for finding reprehensible conduct under the record here. And we believe the fact that every benefit at the full amount, all of the weekly benefits, were paid from the time of the injury through the ultimate disposition of the workers' compensation case.
As an appellate court, though, under our analysis under the Constitution, isn't it our duty to uphold as much of the verdict as we can that's constitutional? I mean, your other argument is that maybe there shouldn't have been punitive damages, but from a pure constitutional analysis, isn't that what our duty is?
Well,
You know, you want us to second-guess the jury, but if we don't second-guess the jury, you end up, I mean, I understand how I read the cases. Our job is to hold up as much as the verdict as we can within constitutional limits.
well, I think that the constitutional limits are what are significant here, and you're correct that that is the ultimate outer limit beyond which punitive damages cannot go. But I don't believe it is a matter of giving deference to a jury because it is de novo review under the constitutional standard. And the State Farm case, Campbell case, is the first time that the court came up with the idea that the application of comparative ratios is a part of the standard that must be reviewed by courts, must be used by courts. And it gave more guidance than it ever had previously on that issue.
It does, but I want to ask you about an opinion by Judge Posner that you may be familiar with. It's a Matthias case. Facts are very much different. It's a bed bug case, so it's not a bad faith case involving a Motel 6 or whatever. But so Judge Posner ultimately upholds a punitive damage number that is well in excess of single digits. And he does so in part by saying, well, he recognizes, as he has to, the Supreme Court case law, but goes on to say that, you know, it's not really a mathematical exercise, and yeah, are you familiar with the case that I'm referring to? I don't know if you are, but I was looking around, as you can well expect, for cases that exceeded the 9 or 10 kind of ratio, and Posner's the one I turned up. And what he basically says is, yes, those are kind of guideposts, but we have to look at the underlying purposes of punitive damages and so forth and so on. And although I understand your argument about de novo review, he also says we have to give some respect to jury determinations and so forth. Anyway, you're smiling. I suspect you have a quick answer for me.
Well, we looked at all of the insurance company bad faith cases that we could find, and there are several dozens since Campbell. We could not find any case that upheld punitive damages anywhere near the 88-to-1 ratio that applies here. We think those cases have substantially more relevance than cases involving some other facts and other conduct.
What about Wilson v. IBP? Realizing that was pre-Campbell, but that had a 500-to-1 ratio?
That's correct. A $4,000 compensatory damage award and a reduced punitive damage award from $15 million down to $2 million. I argued that case in this court 20 years ago. But it is no longer applicable law, because many of the observations in that case have been superseded by U.S. Supreme Court subsequent decisions, including the issue of the comparative ratio of the harm from the punitive damages award and its relationship to the compensatory damages. So I don't believe that the U.S. Supreme Court would uphold the Wilson case today under the standards that are applicable.
And Matthias, the bedbug case, Judge Posner took pains to discuss how the recoverable damages for bedbug bites were relatively small, and yet the importance of a deterrent of a larger punitive damage award. But is that in a different category than this case, where we have a $284,000, what courts would describe as a substantial punitive damage award?
That's why we argue for a 4-to-1 ratio under the comparative standard in the review that this court has. And if one treats it as being substantial, like most, I think, lay people would, $284,000 is quite a bit of money. There's, I think, a good argument that the ratio should not have been more than 1-to-1 between the punitives and the compensatory damages. That's why we say, at least under the Campbell standard, the ratio could not be upheld if it was more than single digits. And it depends really on how the court assesses the arguments over the alleged reprehensible conduct, which we think are much exaggerated or based on a misrepresentation or misstatement of what the record actually shows with respect to American Interstate's handling of this case. Parties had no problems, really, through 2011. Thornton had asked that there not be any discussion of settlement until after his divorce was completed, which was completed late that year.
I understand what you're saying, but the jury found, the court found as a matter of law there was bad faith after March of 2013, but the jury returned a verdict saying the bad faith occurred as early as September of 2009.
We don't think that's supported at all, because what the record shows, there's really nothing that occurred before the parties got into settlement discussions that we contend would support any kind of an accusation of bad faith. There's nothing that the plaintiff ever said. He was given almost immediately after he was ready to talk settlement, after determining that he was not represented at that time by counsel, American Interstate sent a representative along with its claims adjuster to talk to him and submitted some materials to him for him to consider, which would have provided for an appropriate settlement of the case. he understood it was just something on the table that he could discuss and consider with others and with counsel, which is what he did. Really, the only complaints they've got in this record that the district court found constituted bad faith were the two incidents requiring hearings both on the permanent disability issue and the commutation issue. We don't think that he was correct in saying that it was inappropriate to require a hearing to permit the industrial commissioner to determine whether the commutation was in the best interests of the plaintiff. But the court found otherwise. If this court finds that was inappropriate, we still don't believe it supports the kind of punitive damages award under the appropriate standard in this case. Thank you.
Mr. McCormick, thank you as well. Mr. Siems.
Thank you, Your Honor. Your Honors, may it please the court, counsel. I am Tiernan Siems of Erickson Cedarstrom, here with Karen Keeler. We are proud to represent Toby Thornton in connection with this bad faith matter. It's apparent from the court's questioning already that the court is likely well versed with the facts, but there's a couple I would like to hit. And before I do that, I have great respect for my adversary. I think it's unfortunate, however, that there's an accusation that the record's been misrepresented. I think it's imperative that we do talk about some of the facts, and we'll do that also in the context of the punitive damage award. But let me just do this very quickly and chronologically. Of course, on June 25th of '09, Mr. Thornton was paralyzed. He became a quadriplegic and was immediately rendered unemployable. He received Social Security disability benefits very shortly after that. Indeed, the defendant, a multi-billion-dollar national company, adjusted its reserves immediately to reflect permanent total disability. That's worth dwelling on for just a moment. Your Honor, with respect, Justice Waterman, there is a distinction between a dollar figure, in this case, it was being paid on a weekly basis, and permanent total disability benefits. Those are different animals. When there is no doubt but that the claimant is permanently and totally disabled, he is entitled to those benefits earmarked as such. The failure to pay those benefits or otherwise concede that he is permanently and totally disabled results in the type of behavior that we saw in this particular case.
Is that where the September 9 date comes in?
Actually, Your Honor,
2009. I mean, what was that? September 1st, 2009, and
Yeah.
I saw that in the verdict form, but
Your Honor, that date comes from a refusal to provide wage information. Under the Iowa Workers' Compensation Scheme, the employer carrier is obligated, upon request, to provide 1 year's worth of wage information. That was important in this case because, as Mr. Thornton testified, occasionally he was given cash bonuses. Occasionally he was paid something that was not reflected in the wage statement. So his original attorney, not from Erickson Cedarstrom, made multiple requests for the wage statement. They're required to provide that under penalty of a misdemeanor charge within 30 days. The jury fixed that first date of bad faith conduct at that 30-day mark after one of those requests. That's seemingly nominal. However, what the defendant did in doing all of these things that Mr. McCormick points out that they did correct, they attempted to engender some type of trusting relationship with Mr. Thornton while exacerbating his weak bargaining position, refusing to give him information. And it wasn't just a wage statement. It was also the fact that they changed the benefits to permanent and total disability only insofar as the reporting to the commission was concerned. The evidence at trial was that they had an obligation to report that to Mr. Thornton as well. They refused to do it. So, Your Honor, to address your question, that was 30 days after, I think it was a second request that the jury found. There was no defense to the request for that information, which indeed is a benefit under the Act. Information is a
I take it as a truck driver, his wages would vary, and bonuses and overtime and things like that, and those figures are important to fix a weekly rate.
Without a doubt, Your Honor, and it appears, this being a recycling business that Mr. Thornton worked for, the cash bonuses kind of went with how the economy was going or how the business was going from time to time. If there was a large job, Mr. Thornton testified, that's when he might get 100 here or 100 there or things of that nature. We wanted to be able to document that, and you're absolutely right, Your Honor. That was imperative to see if the wage rate was correct.
Apart from the, withholding the information, did that translate into a monetary loss?
Impossible to say, Your Honor, and here's why. It became very apparent early on, this is mediation after we first became involved, when defense counsel, Corey Abbas, in the court below, in the workers' comp court, made threats expressly during mediation. You see that in the email, and you hear that from Jamie Rogers, you hear that from Bill Shirley, defense witnesses. He indicated that among the threats, they would deny everything, they would delay proceedings, they would appeal, they would drive up the attorney's fees because defense was well aware that we were handling this on an hourly basis. So at that point in time, rather than to belabor the issue on the wages, which we asked for many times, we did not want to give them more fodder to further delay proceedings. We tried to expedite everything that we could in this matter. So it's impossible to say whether that would have translated into a monetary difference or not.
What significance, if any, is the fact that there were no penalty benefits awarded by the commissioner?
None whatsoever, Your Honor, for two reasons at least. It's a different standard for one thing. Okay, the second reason is, and this is the only...
Well, it's an easier standard. It's negligence, so it's easier to get those in bad faith. So how does that difference in standard help you?
Well, the standard in the workers' compensation court is as long as it's reasonably debatable. Okay, here where we have punitive damages, this is tantamount to intentional conduct, especially in this particular case. It need not be intentional conduct in the bad faith, or excuse me, in the penalty standard under Chapter 86 or 85. The second reason, though, it's really not relevant, and this is why defense tries to make so much use out of the fact that these weekly payments were being ongoing. That's what it's measured against, is the weekly benefits, that being the penalty, Your Honor. So the fact that there were no penalties in the court below is absolutely irrelevant. The trial court was correct to find as much as well.
Is that 50% additional penalty relevant as a guidepost under Campbell?
Interestingly, the third guidepost that talks about civil penalties, I think the trial court was correct to view that not just as a penalty earmarked as such, as we see in the workers' comp court. For the same reasons I mentioned before, it's not useful as a guidepost. But what the trial court did is also looked at what other civil verdicts are out there that might serve as a civil penalty to a would-be tortfeasor like this. That, I think, is a more important guidepost to use, Your Honor. And when we look at that, we're not just looking at ratios, we're looking at total dollar figures as well. Now, it's interesting that
Hasn't the Supreme Court said that the guidepost is supposed to come from the legislature, it's not just supposed to come, from wherever, right?
Well, it's one of the factors among many, Your Honor, and I would submit, Justice Mansfield, that when we have such reprehensible conduct, the other guideposts are not quite as relevant, okay? So when we look at the reprehensible conduct in this particular case, this isn't just an economic harm. This is actually a physical harm, which I would include as physical and mental. So, Your Honor, when we look at that third guidepost, compare it to the jury instruction. The jury instruction which says the punitive damages are not meant to put a company out of business. They are meant to dissuade that bad actor from repeating like offenses and send a message to other would-be tortfeasors. Unfortunately, the defendant in this particular case ignored any of those prior civil penalties that were not enacted but were judicial decisions. They ignored those absolutely. It's interesting, and I almost a little bit...
If Ground and ask you one other question about the punitive damages, can you give me the appellate case since Campbell that you think is kind of your best case to support this particular punitive damage verdict?
Well, at least two, and as a matter of fact, there's two more that were just recently decided in December. The two would be the Philip Morris case out of Oregon that was appealed to the U.S. Supreme Court, and the U.S. Supreme Court ultimately said, listen, this needs to be remanded for a full analysis. It was remanded, full analysis conducted. We had a much greater proportion than what we see in this case. The other one is TXO. Okay, those two cases, both of which are cited in the briefs, Your Honor, I think would be appellate decisions at a federal level that show that the proportion we have here is relatively modest. And then, of course, we do have
Counsel, the ratio in Philip Morris was 100 to 1. What was the ratio in TXO? I don't recall.
It was in excess of 516 to 1, if I recall correctly. It was greatly in excess of that. Interestingly, the ratio in this case, although 88 to 1 under the current damages, we would submit should be about 40 to 1 because we think that the trial court should have awarded attorney's fees in prosecuting the bad faith claim as well.
Have we ever allowed that as opposed to awarding attorney's fees in the underlying action?
Well, in the underlying action, you say, Your Honor, because this was a workers' compensation claim.
And the jury did give, what, $100,000 or so for full compensation for the fees in the work comp case.
That was absolutely uncontested, and they did give that, but that amount was driven by the activities of the defense.
When have we allowed an award of fees for prosecuting the bad faith case?
Well, there's two scenarios. One is where the conduct is conniving and egregious in that regard.
I understand the scenarios, but when has our court upheld an award of fees for prosecuting the bad faith claim?
I don't have a citation as I say it here, Your Honor, and I would draw a distinction between the bad faith with a workers' comp as compared to any other type of bad faith. So we think that the standard applies, and it should apply in this particular case, both because of the test and the common law principle in prosecuting the bad faith.
You had mentioned physical and emotional harm, and is there evidence that his depression was caused by American Interstate? I note the medical records. He refers to other, his death of his mom, his wife leaving him, but was the conduct of the insurance company shown to be a source of his mental anguish?
When we look at Gibson, we learn that where a plaintiff is so mentally fragile and vulnerable, when there is evidence of this type of conduct, the jury could reasonably infer that there was an exacerbation or aggravation of that mental state. We concede the defendant didn't cause Mr. Thornton to overdose on medication. We've never made that argument. The defense has tried to make that our argument in order to build a straw man to beat down. We don't take that argument whatsoever. But what it does demonstrate is we had a very fragile person. They knew it. It's in the medical records that they received, and they knew that he tried to take his own life. They knew that he was to his limit. And in those circumstances, that's when they approached him, having refused to give him information, not just the wage information, but the conversion of benefits insofar as the commission was concerned. Those had already happened when they approached him and said, we've got a deal for you. And again, we don't take the position that offering a settlement through an annuity or a structured settlement is bad faith. Absolutely not. Amicus curiae are incorrect to characterize the argument that way, as is defense. To try and strong-arm a plaintiff and exacerbate his financial, emotional, physical disabilities, that is bad faith, and the jury so found.
Could you address the defendant's argument that reprehensibility is not established because he was getting the weekly benefits all along the way?
That was one of the things I started with, Your Honor, and I noted that was one of your questions before. I cannot emphasize enough, and if you look at the last iteration of the petition filed in this case and the defendant's answer, they acknowledge permanent total disability benefits are a different benefit under the statute. Paying the weekly dollar figure does not make it permanent total disability. So, paying that dollar figure, as the trial court said, does not buy them out of the obligations created under bad faith. Permanent total disability benefits are a benefit under the Workers' Compensation Act. They knew they had no valid defense when they informally and formally said you are not permanently and totally disabled. Knowing that they had no reasonable basis for that, they instead drove up his attorney's fees. They delayed his day in court on the partial commutation. You remember, Your Honor, in Gibson, that was the conduct that caused the bad faith in that case. Incidentally, Mr. McCormick was also counsel in the Gibson case. Gibson was post-BMW. Gibson did not overturn Wilson. I'm not quite sure why Mr. McCormick thinks that Wilson is no longer good law. But be that as it may, Your Honor, the threats were made good, and they were allowed to exercise those threats because they never designated those as permanently and totally disabled benefits, and they took the exact opposite position, informally and then formally at trial.
Did they underpay him in any particular week?
We'll never know, because, Your Honor, they withheld the annual wage statements that they were required to give under penalty of misdemeanor.
So you've,
Thanks. Quickly, when we look at the reprehensibility of the conduct, is there evidence that the insurance company intentionally delayed ordering his replacement wheelchair that led to the elbow injury?
Absolutely.
And what is the evidence that they intentionally delayed?
Jamie Rogers, if you compare, she gave 2 depositions in working the case up. And let's just forget for a moment, because this is also a basis for that, their prior conduct and their threats. We will deny, we will delay any benefit, we will appeal. Jamie Rogers' first deposition, she said, I'm unaware of any order or request for a wheelchair, but if I'm ordered to, I will provide one. When she gave that deposition, that was months after Dr. Rogie had already prescribed a wheelchair, unbeknownst to us. We were just asking the question because it was about the 5-year mark when Dr. Broghammer, their own IME physician, said he would ordinarily need a replacement. So Ms. Rogers, a claims representative at that point in time, said, I'm unaware of any wheelchair. If I'm ordered to replace it, I will, but only if ordered to do so. The next time we took her deposition, we had then uncovered those records, and she had said, oh yeah, I had that maybe a week afterwards. She lied. She lied, and you can't reconcile her testimony between the two. I see that I'm out of time. We'd ask that the court affirm the verdict in all respects.
Counsel, I think we have another question for you.
Certainly.
Before you sit down, it seemed to me in your brief that you focused, in terms of your position on reprehensibility, to a great extent on the carrier's conduct in the commutation aspect of the case. You haven't really talked about that. So would you just briefly give us the overview of why the conduct during the commutation phase of the case was reprehensible and in bad faith?
It's not that they asked Mr. Thornton to prove up. Again, that's a straw man. That's not our argument. It's that they delayed his court a la Gibson. That's exactly the conduct that in Gibson was found to give rise to bad faith. In Gibson, it was a workers' compensation claim. They initially admitted the claim, but as soon as the claimant tried to get alternate medical care, as would be their right for an admitted claim, and filed a petition to get that, the defense thwarted that effort by then denying the claim. That made the alternate medical care evaporate. And the court found, and the jury found, that that was done in bad faith. They delayed the plaintiff's day in court intentionally so. That's what happened here with the partial commutation. More than that, they also made misrepresentations to the court, to the plaintiff, and to witnesses in defending the partial commutation. It's one thing, Your Honor, to say, you prove up. We're entitled for you to prove up to the commissioner's satisfaction. It's another thing to affirmatively say, it's not in your best interest, and we're going to take affirmative steps to try and prove that. And particularly when the steps they took were frivolous, were misrepresentations, a fraud upon the court.
Mr. Siems, Mr. McCormick offered us a single-digit multiplier in guiding us in the amount of punitive damages. Did you offer us any?
Well, I think that 44 to 1 if the court were to award its attorney's fees, or the present amount awarded. Here's why. When we look at the evidence, not only do we have a multiplier that's below Gibson, below Wilson, below TXO, below the Philip Morris case in Oregon, below the 2 recent cases from state courts, one in Arkansas, one in either Kentucky or Oklahoma. But what we have is the evidence that supports this. How are we to dissuade this bad actor in the future when we have testimony from the claims manager saying $20 million is not going to affect the way we do business? Paraphrasing, of course, Your Honor. So when we look at that, and that didn't change your conduct one iota, I would submit that the $25 million is what is required in this case to send a message to this bad actor and other would-be bad actors. So, Your Honor, I would submit that it's 88 to 1, or in the event that the court awards attorney's fees, it would be 44 to 1. Thank you, Your Honors.
Thank you, Mr. Siems. Mr. McCormick?
I'll try to address a few of the remarks that Mr. Siems made that I think deserve response. One, as to the alleged failure to provide this wage information. The record shows really without dispute that American Interstate from the beginning paid the maximum amount that this plaintiff would have been entitled to during the period of the payments that were med prior to the time that the workers' compensation case was disposed of finally. So there was no impact. If there was a failure to produce a wage record with respect to a particular week, which the record doesn't really show, there was no impact. And so that is really why that, I think.
It seems to me, though, stuff like that goes to show that this company wasn't really wanting to pay this claim, really, they were, but really causing this guy trouble because, a partial permanency, you get lifetime medicals and you get, your weekly rate and you're done. And after 3 years, it's mathematically sound to commute if you want to commute. But this company just, I'm going to appeal, I'm going to do this, I'm not giving you your wages. It just seems like a whole course of conduct over this claim that would support a bad faith finding by this jury.
I don't believe the record supports that allegation. In fact, the record shows that the company went out of its way to accommodate all of the needs of Mr. Thornton and paid for them, remodeling of the in-laws' home, getting him a customized van, assisting him so that he could pass the driver's test for that. The company spent more than $1 million even before the end of 2011 on meeting the medical and other needs of Mr. Thornton. And I just don't buy this notion that that there was any kind of a misconduct that occurred other than what the court, as a matter of law.
The jury bought it, and that's the thing we have to look at if there is substantial evidence. Now, we may come to a different conclusion, whether it is or isn't, but if there's substantial evidence, which doesn't mean substantial, it means evidence that's admissible, we have to uphold the verdict.
We have a number of contentions in our brief, one of which is that there was never any showing of a breach of contract in this case, which is an essential predicate for any award of punitive damages. So we don't give up on those arguments. We simply don't want to take the time to occupy you with all of the answers. But I do want to address this allegation that we knew of some mental fragility because we knew that he had overdosed and had been hospitalized before we made our first approach to him to settle a case. That's one of the misstatements of the record, because we did not know that he had been hospitalized for mental health care until shortly before the trial that occurred in 2015. And that hospitalization occurred in 2011. So there's no evidence in this record that there was any knowledge that was communicated to American Interstate about any issue with his mental health. And there is nothing in any testimony from Toby Thornton that would support a finding that he suffered at all any mental pain or suffering, or even any physical pain or suffering that could be attributable to American Interstate. And the wheelchair issue we've addressed in our brief. If you look at what is cited for the purported knowledge of the claims adjuster Rogers about the ordering of the wheelchair, which was the doctor's responsibility, it is based on, apparently, as best I can figure out by looking at the transcript and appendix on that issue, on the fact that the bills of Dr. Rogie were being paid by American Interstate. And if the claims adjuster had scrutinized a bill in July of 2014, she should have known that the wheelchair had been ordered, and she should have known that it was overdue, and that she should act proactively to get the doctor, to get the information to the hospital so that they would measure Thornton and get this.
One question. There was an allegation or a statement by your opposing counsel that the claims adjuster said $20 million isn't going to change our attitude. What was that about?
That was in the deposition of one of the officials on the notion of chain of command at American Interstate, when he was asked on cross-examination by Mr. Siems if it would drive American Interstate out of business if they had to pay $20 million in punitive damages. And he said, in effect, we can afford to pay that amount of money. That is not part of the standard for an award of punitive damages. But apparently that is what he's relying on.
Chief, could I ask one more? Mr. McCormick, when I asked Mr. Siems about post-Campbell state or federal, whatever, appellate authority that would support the punitive damage award in this case, he gave me TXO, which is pre-Campbell, but then he also gave me Philip Morris. To address that, if you could.
Yes, I'm glad I intended to, and I just not thought of it. The Oregon case, Philip Morris case, had been to the Supreme Court twice. It was a tobacco case with a huge award twice. And it had been reversed and remanded, sent back to Oregon by the Supreme Court twice. There was a third case, third award that was taken, that was subject of a cert petition by the insurance company in that Philip Morris case, and the Supreme Court denied cert. So their claim is, of course, that meant the Supreme Court agreed with the Philip Morris decision the third time around, which is inaccurate. And the Oregon Supreme Court, in the Goddard case that we have cited in our brief, addressed that issue and said specifically that Campbell required in the Goddard case, where there had been a substantial punitive damages award, that the court cut the award because of the issue of excessiveness based on its analysis of the comparison of the award in Goddard to the harm that was involved in that case. So Goddard interpreted and addressed the issue of the impact of the Philip Morris case and said, it does not affect what we need to do in this case, and it didn't affect it. So their own interpretation supports the notion that in Oregon, the Campbell standard will be applied in insurance bad faith cases, same way it should be here.
I haven't read that case, but I will. I'm just curious, what was their explanation for why Philip Morris was different?
The fact that there was over 50 years of misleading advertising by the cigarette company, which had led to all of the problems that people had from the disease and other issues that arose from smoking. So it was one of the smoking cases involving the deception, allegedly by the cigarette companies, over the harm that was being caused for a period of years. So that's an important distinction and has some relevance, I think, to the Posner case that Justice Appel talked about. And that's why we believe the cases that here are controlling are those that involve insurance company bad faith in circumstances that at least can be analogized in some way to those in this case. Thank you.
Thank you as well, Mr. McCormick, and again, Mr. Siems, thank you. The case of Thornton versus American Interstate is now then submitted to the court.